Analyzing case law and legal precedents. The importance of case law analysis. Ladies and gentlemen, case law analysis stands as a cornerstone of legal research, playing a pivotal role in understanding legal principles, tracking the evolution of legal doctrines, and predicting future trends in jurisprudence. This process extends far beyond a mere reading of court decisions. It demands critical thinking, contextual understanding, and the ability to synthesize information across multiple cases. The skill of effective case law analysis is indispensable for legal scholars and practitioners alike, as it forms the foundation for constructing robust legal arguments and contributing to the development of the law. Mastery of this skill allows researchers to navigate the complex web of judicial decisions, extracting key principles and insights that shape the legal landscape. Locating relevant case law. Dear listeners, the process of locating pertinent case law is fundamental to effective legal research and analysis. Utilizing legal databases such as Westlaw, LexisNexis, and Hein Online requires a strategic approach to keyword searches, leveraging Boolean operators and proximity connectors to refine results. For instance, a search string like autonomous vehicle /P liability /S negligence can yield targeted results in emerging areas of tort law. Topic systems and key number digests, particularly in Westlaw, offer systematic pathways to relevant cases within specific legal domains. Citators like Shepard's and Keycite not only validate a case's current status but also provide a roadmap of related decisions, enabling researchers to track the evolution of legal principles. Identifying seminal cases often involves consulting secondary sources such as law review articles, treatises, and legal encyclopedias, which frequently distill key precedents in a given area. The procedural posture of a case can significantly impact its relevance. For example, summary judgment decisions may offer more substantive legal analysis than cases dismissed on procedural grounds. Recognizing circuit splits or conflicting precedents is crucial for understanding areas of legal uncertainty and potential for future Supreme Court review. Analyzing court opinions. Effective analysis of case law begins with a thorough understanding of the structure of court opinions and the underlying legal reasoning. The typical structure of a court opinion: facts, issue, rule, analysis, and conclusion provides a framework for extracting key information. Distinguishing between ratio decidendi, the binding principle of a case, and obiter dicta, persuasive but non-binding commentary, is crucial for accurately determining a case's precedential value. Legal reasoning in judicial opinions may employ various forms, including deductive reasoning, applying general rules to specific facts, analogical reasoning, drawing parallels with previous cases, and policy-based reasoning, considering broader societal implications. Analyzing the court's application of legal principles to facts reveals the nuanced process of judicial decision-making. Concurring and dissenting opinions offer valuable insights into alternative legal interpretations and potential future directions of the law. Identifying implicit assumptions in judicial reasoning can uncover underlying biases or policy preferences that influence outcomes. Synthesizing multiple cases. The synthesis of multiple cases is a critical skill in legal research, enabling the identification of broader legal principles and trends across a body of jurisprudence. This process involves recognizing common threads or principles that emerge from diverse factual scenarios and judicial opinions. Case comparison charts or matrices can be invaluable tools for visually representing similarities and differences across cases, facilitating the identification of patterns or inconsistencies. For example, a matrix comparing privacy cases across jurisdictions might reveal evolving standards for reasonable expectations of privacy in the digital age. Tracking the evolution of legal doctrines through case law requires attention to subtle shifts in language and reasoning over time. Reconciling apparently conflicting decisions often involves close analysis of factual distinctions or changes in the broader legal landscape. Effective case synthesis in legal writing requires a balance between presenting individual case details and articulating overarching legal principles. Understanding precedent and stare decisis. The doctrine of stare decisis, fundamental to common law systems, underscores the importance of precedent in legal analysis. Determining the binding authority of a case requires understanding the hierarchy of courts and the principles of vertical and horizontal stare decisis. For instance, in the U.S. federal system, district courts are bound by circuit court decisions within their jurisdiction, while circuit courts are bound by Supreme Court precedents. Assessing the persuasive value of non-binding precedents involves considering factors such as the reputation of the deciding court, the thoroughness of its reasoning, and the similarity of the legal and factual context. Identifying cases that may be ripe for overturning requires recognizing shifts in social norms, technological advancements, or evolving legal doctrines that challenge the foundations of earlier decisions. The concept of a case being distinguishable from the current legal issue is crucial, allowing courts to narrow or expand the application of precedents based on factual or legal differences. Contextual analysis of cases. Understanding the historical and social context of cases is essential for a comprehensive analysis of their significance and ongoing relevance. This contextual approach involves researching the background circumstances surrounding a decision, including contemporaneous social movements, political climate, and economic conditions. For example, analyzing Brown v. Board of Education requires understanding the civil rights movement and the social realities of racial segregation in 1950s America. The composition of the court can significantly impact decision-making, as seen in the shifts in U.S. Supreme Court jurisprudence following new appointments. Assessing the influence of public opinion or social movements on case outcomes provides insights into the dynamic relationship between law and society. Landmark decisions often reflect broader societal changes or respond to pressing social issues, as exemplified by cases like Obergefell v. Hodges on same-sex marriage. Understanding the practical implications of a case at the time it was decided, as well as its long-term impact on legal practice and society, is crucial for evaluating its enduring significance. Analyzing cases in emerging legal fields. Dear listeners, in fast-changing legal fields, such as technology law, environmental law, or bioethics, case law analysis requires a dynamic approach that anticipates future developments. Identifying emerging trends or shifts in judicial reasoning often involves looking beyond traditional legal sources to interdisciplinary research and policy debates. For instance, in the rapidly evolving field of artificial intelligence law, courts are grappling with novel issues of liability, intellectual property, and privacy, often drawing analogies from established legal principles in new contexts. Analyzing the impact of technological or social changes on case law requires a forward-looking perspective, considering how emerging technologies or shifting social norms might challenge existing legal frameworks. In areas with limited precedent, such as cryptocurrency regulation, courts may rely more heavily on policy considerations and comparative law. Balancing established precedents with novel legal challenges often involves creative legal reasoning, as courts attempt to apply traditional principles to unprecedented situations. Critical evaluation of judicial reasoning. Critically evaluating the logic and coherence of court decisions is essential for rigorous legal scholarship and effective advocacy. This process involves scrutinizing the court's arguments for logical consistency, factual support, and adherence to legal principles. Identifying potential biases or assumptions in judicial reasoning requires careful attention to language choice, selective use of precedents, and underlying policy preferences. For example, critiques of the Supreme Court's decision in Citizens United v. FEC have focused on the court's assumptions about corporate speech rights and the nature of corruption in political spending. Assessing the clarity and persuasiveness of a court's arguments involves evaluating the structure of the opinion, the strength of the evidence cited, and the effectiveness of the court's responses to counterarguments. Analyzing the practical implications of a court's reasoning is crucial for understanding the decision's real-world impact and potential for future application or distinction. Comparative case law analysis. Comparative analysis of case law across different jurisdictions offers valuable insights into diverse approaches to common legal problems and can inform arguments for legal reform or harmonization. This approach involves identifying similarities and differences in legal reasoning between courts, considering factors such as legal traditions, societal values, and institutional structures. For instance, comparing approaches to privacy rights in the EU, with its emphasis on data protection as a fundamental right, and the U.S., where privacy protections are more fragmented, reveals contrasting legal philosophies and regulatory approaches. Analyzing the influence of one jurisdiction's case law on another's can illuminate processes of legal transplantation and cross-border judicial dialogue. Comparative case analysis is particularly valuable in areas of global concern, such as climate change litigation, where courts worldwide are grappling with similar issues but may reach different conclusions based on local legal and policy contexts. Interplay between case law and statutory interpretation. Dear listeners, the interplay between case law and statutory law is a fundamental aspect of legal analysis, particularly in codified legal systems. Case law often serves to interpret, apply, and sometimes challenge statutory provisions, playing a crucial role in shaping the practical impact of legislation. Analyzing how courts have interpreted specific statutory provisions involves examining the methods of statutory interpretation employed, such as textualism, purposivism, or dynamic interpretation. Case law can be instrumental in clarifying ambiguous statutory language, filling gaps in legislative schemes, and resolving conflicts between different statutory provisions. Analyzing the impact of statutory changes on existing case law is crucial for understanding the dynamic nature of legal development, particularly in areas subject to frequent legislative reform. The role of case law in constitutional interpretation is particularly significant, as seen in the development of doctrines like substantive due process or equal protection, which have significantly expanded the scope of constitutional rights beyond the text's literal meaning. Incorporating interdisciplinary sources in legal research. The significance of interdisciplinary research in law. The integration of interdisciplinary sources in legal research has become increasingly paramount in addressing the complex, multifaceted challenges of contemporary legal scholarship and practice. This approach recognizes that the law does not operate in isolation but is deeply intertwined with social, economic, technological, and ethical dimensions of society. Incorporating insights from diverse disciplines can significantly enrich legal analysis, offering novel perspectives on intricate legal issues and fostering innovative solutions to pressing juridical problems. However, this integration requires careful consideration of the relevance and applicability of non-legal sources to specific legal questions. The interdisciplinary approach enables legal scholars to transcend traditional boundaries, leading to more comprehensive and nuanced understanding of legal phenomena. Benefits of interdisciplinary perspectives in legal research. The incorporation of interdisciplinary perspectives in legal research offers myriad benefits, fundamentally enriching the depth and breadth of legal analysis. This approach enables scholars to transcend traditional legal paradigms, offering fresh insights into long-standing legal problems and illuminating new avenues for inquiry. Seminal works in law and economics, such as Cosa's The Problem of Social Cost, have revolutionized understanding of property rights and liability rules, demonstrating the profound impact of interdisciplinary thinking on legal doctrine. Similarly, research at the intersection of law and psychology has significantly influenced areas like eyewitness testimony and jury decision-making, highlighting the practical relevance of interdisciplinary approaches. Interdisciplinary research plays a crucial role in addressing complex societal issues that defy simple legal solutions, such as environmental regulation or data privacy protection. By challenging traditional legal assumptions, interdisciplinary work can spur legal innovation and reform. For instance, behavioral law and economics has prompted re-evaluation of rational actor models underlying many legal doctrines. Strategies for identifying relevant interdisciplinary sources. The process of identifying relevant interdisciplinary sources for legal research demands a strategic and methodical approach. Researchers must develop proficiency in navigating interdisciplinary databases such as JSTOR, Web of Science, or subject-specific repositories, employing advanced search techniques to pinpoint relevant non-legal literature. Effective use of Boolean operators, subject headings, and citation tracking can uncover connections between legal issues and pertinent work in other disciplines. Identifying key scholars or seminal works in relevant non-legal fields often serves as a gateway to broader interdisciplinary literature. For instance, in research on law and artificial intelligence, familiarization with foundational works by computer scientists like Stuart Russell and Peter Norvig can provide crucial context. Evaluating the credibility and authority of non-legal sources requires careful consideration of factors such as the author's expertise, the publication's peer review process, and the work's impact within its field. Citation analysis tools like Google Scholar or Scopus can reveal interdisciplinary connections and the influence of particular works across disciplinary boundaries. Integrating social science research in legal studies. The incorporation of social science research into legal studies has become increasingly vital, offering empirical grounding and theoretical frameworks that can significantly enhance legal analysis. Social science methodologies, ranging from quantitative statistical analyses to qualitative ethnographic studies, provide tools for rigorously examining the social context and impact of legal rules and institutions. For example, empirical studies on racial disparities in criminal sentencing have informed legal debates on judicial discretion in sentencing guidelines. Critical evaluation of social science studies for legal applicability involves assessing the relevance of the research question, the appropriateness of the methodology, and the generalizability of findings to legal contexts. Interpreting statistical data from social science research requires legal scholars to develop basic statistical literacy, understanding concepts such as statistical significance, effect sizes, and limitations of data analysis. Social science theories, such as deterrence theory in criminology or cognitive dissonance in psychology, can provide valuable frameworks for developing and testing legal hypotheses. Economic analysis in legal research. Dear listeners, economic analysis has profoundly influenced legal scholarship, offering analytical tools and theoretical frameworks for evaluating the efficiency and consequences of legal rules. Key economic concepts relevant to legal analysis include efficiency, incentives, transaction costs, and cost-benefit analysis. For instance, the Coase theorem has been instrumental in analyzing property rights and liability rules, demonstrating how, under certain conditions, efficient outcomes can be achieved regardless of initial legal entitlements. Integrating empirical economic studies into legal arguments requires careful evaluation of methodological approaches and underlying assumptions. For example, empirical studies on the deterrent effect of punitive damages in tort law have informed debates on tort reform. Law and economic scholarship has been particularly influential in areas such as antitrust law, contract theory, and corporate governance. The work of scholars like Guido Calabresi and A. Mitchell Polinsky has demonstrated how economic analysis can inform legal policy decisions. However, it is crucial to address potential conflicts between economic efficiency and other legal values, such as fairness or distributive justice. Historical analysis in legal research. Historical analysis plays a crucial role in legal research, providing context for the development of legal doctrines and institutions, and offering insights into the social, political, and economic factors that shape law over time. Incorporating historical research methods in legal studies involves engaging with primary sources such as historical legal documents, legislative histories, and archival materials. For example, analysis of the Federalist Papers and Constitutional Convention debates continues to inform interpretations of the U.S. Constitution. Evaluating the relevance of historical events or trends to current legal issues requires careful consideration of both continuities and changes in legal and social contexts. This slide shows that the historical analysis can be particularly valuable in challenging or supporting current legal interpretations, as demonstrated by the use of originalist arguments in constitutional law. The work of legal historians like Lawrence Friedman has illustrated how historical perspectives can illuminate the social functions of law and the processes of legal change. Integrating oral histories or non-traditional historical sources can provide valuable insights into the lived experiences of law, particularly for marginalized groups often underrepresented in official legal records. Philosophical and ethical analysis in legal research. Philosophical inquiry and ethical analysis have long been integral to legal theory, offering conceptual frameworks for examining the foundations and justifications of legal systems. Identifying relevant philosophical concepts or arguments for legal research often involves engaging with classic works of legal philosophy, such as H.L. A. Hart's The Concept of Law or John Rawls's A Theory of Justice. Integrating ethical theories into legal reasoning can provide normative foundations for evaluating laws and policies, as seen in debates over issues like assisted suicide or environmental protection. Analyzing the philosophical foundations of legal principles involves critically examining underlying assumptions about justice, rights, and the nature of law itself. For instance, Ronald Dworkin's work on law as integrity has influenced approaches to constitutional interpretation. The use of thought experiments or hypotheticals from philosophy, such as the trolley problem, in discussions of criminal liability, can illuminate ethical dimensions of legal issues. Balancing philosophical rigor with legal pragmatism requires careful articulation of how abstract philosophical concepts relate to concrete legal problems. Integrating scientific and technological knowledge. The integration of scientific and technological knowledge in legal research has become increasingly crucial as the law grapples with rapid advancements in fields such as biotechnology, artificial intelligence, and environmental science. Identifying relevant scientific or technical sources for legal questions often requires collaboration with experts or extensive interdisciplinary reading. For example, research on the legal implications of climate change necessitates engagement with climate science literature. Evaluating the credibility and reliability of scientific evidence is paramount, particularly in areas where scientific consensus is evolving or contested. Legal scholars must develop skills in interpreting scientific data and statistics, understanding concepts such as statistical significance, margins of error, and methodological limitations. Addressing potential conflicts between scientific findings and legal precedents often involves careful consideration of how to adapt legal doctrines to new scientific realities. The integration of neuroscientific evidence in criminal law, as explored by scholars like Stephen Morse, illustrates both the potential and challenges of incorporating cutting-edge scientific knowledge into legal frameworks. Challenges and limitations of interdisciplinary legal research. Dear listeners, while interdisciplinary approaches offer significant benefits to legal research, they also present unique challenges and limitations that must be carefully navigated. One primary difficulty lies in reconciling different methodological approaches across disciplines, each with its own epistemological assumptions and standards of evidence. For instance, integrating qualitative sociological research with doctrinal legal analysis may require bridging fundamentally different approaches to knowledge production. Addressing terminology and conceptual differences between fields is crucial, as terms may carry distinct meanings across disciplines. Maintaining legal rigor while incorporating non-legal insights demands a delicate balance, ensuring that interdisciplinary perspectives enhance rather than dilute legal analysis. Potential biases or limitations in interdisciplinary sources must be critically evaluated, particularly when applying findings from one context to legal questions. Skepticism towards interdisciplinary approaches in legal academia can present barriers, requiring researchers to clearly articulate the value and relevance of non-legal insights. Ethical considerations specific to interdisciplinary research in law, such as maintaining confidentiality across disciplinary boundaries or navigating different ethical standards, must be carefully addressed. Synthesizing interdisciplinary insights in legal writing. The effective synthesis of interdisciplinary insights in legal writing is a critical skill that enables researchers to construct compelling, multifaceted arguments. Structuring interdisciplinary legal papers or theses often involves carefully weaving together legal analysis with perspectives from other disciplines, maintaining a clear legal focus while demonstrating the added value of interdisciplinary approaches. Balancing legal analysis with interdisciplinary perspectives requires judicious selection of non-legal insights that directly inform or challenge legal understanding. Using interdisciplinary insights to strengthen legal reasoning might involve, for example, employing psychological research on cognitive biases to critique the reasonable person standard in tort law. Addressing potential contradictions between disciplinary viewpoints in writing demands transparent acknowledgement of differing perspectives and clear articulation of how these tensions inform legal analysis. Effective interdisciplinary synthesis in legal scholarship is exemplified by works like Cass Sunstein and Richard Thaler's Nudge, which seamlessly integrates behavioral economics with legal policy analysis. The key is to maintain a clear legal focus while leveraging interdisciplinary insights to deepen understanding and propose innovative solutions to legal challenges. Using Boolean operators and advanced search techniques. Understanding Boolean logic in legal research. Dear listeners, Boolean logic forms the cornerstone of effective database searching in legal research. The primary Boolean operators and, or, and not serve as powerful tools for constructing precise search queries. The AND operator narrows search results by requiring all specified terms to be present. For instance, copyright and infringement in digital would return only documents containing all three terms. Conversely, the OR operator broadens searches by including results with any of the specified terms, useful for capturing synonyms or related concepts, such as contract or agreement or covenant. The NOT operator excludes specified terms, helping to eliminate irrelevant results, as in discrimination not employment, to focus on non-workplace discrimination cases. Boolean algebra principles allow for the construction of complex queries using parentheses to group terms and establish a hierarchy of operations. For example, copyright or patent, and infringement and digital or online creates a nuanced search for intellectual property infringement in digital contexts. Proper use of Boolean operators can dramatically improve search efficiency, but researchers must be aware of potential pitfalls, such as overly narrow searches that might exclude relevant results or overly broad queries that yield unmanageable result sets. Advanced search features in legal databases. Major legal databases like Westlaw, LexisNexis, and Hein Online offer a range of specialized search features that extend beyond basic Boolean logic. Field searching allows researchers to target specific parts of legal documents, such as the title, author, or court name, enhancing precision in document retrieval. For instance, in Westlaw, a search like TI, Miranda rights, would specifically target documents with Miranda rights in the title. Proximity operators, such as /n, /p, or /s, enable searches for terms within a specified distance of each other, crucial for identifying relevant legal phrases or concepts. For example, hearsay /5 exception would find instances where these terms appear within 5 words of each other, likely capturing discussions of specific hearsay exceptions. Wildcard and truncation symbols, e.g., or, allow for searching variations of terms, such as negligent asterisk, to capture negligence, negligent, and negligently. Segment searching in LexisNexis enables targeting of specific parts of legal documents, like the summary or dissenting opinion. Numerical range searching is particularly useful for statute or case law research, allowing queries like date, AF 2010, and date, BEF 2020, to focus on a specific decade. Constructing effective search queries. The art of constructing effective search queries in legal research begins with a meticulous breakdown of research questions into searchable concepts. This process involves identifying key terms, their synonyms, and related legal concepts that may be relevant to the inquiry. For instance, a research question on the liability of autonomous vehicle manufacturers might be deconstructed into concepts like autonomous vehicles, product liability, negligence, and artificial intelligence. Utilizing controlled vocabulary or database-specific indexing terms, such as West's key number system, can significantly enhance search precision. Balancing precision and recall in legal search queries requires careful consideration. Overly narrow searches may miss relevant documents, while excessively broad queries can overwhelm with irrelevant results. Legal terms of art and common language variations must be accounted for, often necessitating the use of synonyms or alternative phrasings. For example, a search on corporate veil piercing might include terms like disregard corporate entity or alter ego doctrine. Constructing searches for different types of legal materials may require distinct approaches. Case law searches often benefit from factual scenario descriptions, while statutory searches might focus on specific language or section numbers. Leveraging proximity operators. This slide shows that the proximity operators are invaluable tools in legal research, allowing for nuanced searches that capture the relationship between terms more precisely than simple Boolean operators. These operators specify the maximum number of words that can separate the search terms, thereby enhancing the relevance of search results. For example, in Westlaw, the search '3 punishment would find instances where these terms appear within 3 words of each other, likely capturing phrases like capital case punishment or punishment in capital cases. Different legal databases offer various proximity operators, such as /n within n words, /p within the same paragraph, or /s within the same sentence. The choice of proximity setting depends on the nature of the legal concept being researched. Tightly connected phrases might use a smaller word distance, while broader legal principles might allow for greater separation. Proximity operators can be particularly effective in identifying specific legal doctrines or tests, as in undue/5 hardship, to locate discussions of this concept in employment law. These operators can also help uncover relationships between legal concepts that might not be immediately apparent, such as privacy/10 technology, to explore the intersection of privacy law and technological developments. Advanced filtering and narrowing techniques. Advanced filtering and narrowing techniques are essential for managing the often overwhelming volume of results in legal database searches. These methods allow researchers to refine large result sets based on various criteria, enhancing the efficiency and relevance of the research process. Date filtering is particularly crucial in legal research, enabling focus on specific time periods relevant to the development of legal doctrines or the applicability of precedents. Jurisdictional filters help narrow results to relevant courts or geographical areas, essential in a federated legal system like the United States. Faceted searching, a feature in many modern legal databases, allows for dynamic filtering of results based on multiple dimensions such as document type, practice area, or court level. For instance, a researcher might start with a broad search on environmental regulation, and then progressively narrow the results to federal appellate cases from the last 5 years dealing with air quality standards. Subject or topic filters, often based on proprietary classification systems like West's key number system, enable researchers to focus on specific legal issues within broader search results. Citation frequency or depth of treatment filters can help identify seminal cases or extensively discussed legal principles. Searching primary legal sources. Effective searching for and within primary legal sources statutes, regulations, and case law requires specialized techniques tailored to the unique structures and characteristics of these materials. For statutory research, familiarity with the organization of legal codes is crucial. Researchers can use specific title or section numbers to target relevant provisions, such as 17 U.S. C. Section 107 inch for the U.S. Copyright Act's fair use provision. Statutory indices and tables of contents, often searchable in digital formats, provide valuable entry points for exploring legislative schemes. Techniques for searching legislative history materials, including committee reports and floor debates, often involve targeting specific bill numbers or congressional session information. In case law research, party names and docket numbers serve as unique identifiers for locating specific decisions. Searching within court opinions often benefits from targeting specific sections, such as the holding or dissenting opinions, to focus on key legal reasoning. Citation searching is a powerful tool for tracking the treatment and interpretation of primary sources over time. For instance, using Shepard citations or KeyCite allows researchers to identify cases that have cited, distinguished, or overruled a particular decision. Searching secondary legal sources. Secondary legal sources, including law reviews, treatises, and practice guides, offer invaluable commentary and analysis that can guide and enrich primary source research. Effective searching of these materials requires tailored approaches that account for their diverse formats and purposes. When searching law reviews and journals, utilizing author and title fields can help locate works by specific scholars or on particular topics. For comprehensive coverage of a legal issue, subject or topic searches across multiple journals can reveal the breadth of academic discourse. Searching within specific sections of legal treatises or encyclopedias, such as chapter titles or section headings, can quickly direct researchers to relevant analysis. Practice guides and form books often benefit from searches targeting specific legal procedures or document types, such as motion for summary judgment or LLC operating agreement. Legal dictionaries and thesauri require precise searching for terms of art or legal concepts, often providing cross-references to related terms. Citation searching in secondary sources can track the academic discussion and impact of primary legal authorities, revealing how scholars have interpreted and applied key cases or statutes. Interdisciplinary search strategies. Dear listeners, interdisciplinary legal research often necessitates venturing beyond traditional legal databases into resources from fields such as social sciences, economics, or technology. This cross-disciplinary approach requires adapting legal search strategies to navigate unfamiliar terrain. Identifying relevant non-legal databases, such as PsycInfo for law and psychology research or EconLit for law and economics, is a crucial first step. Adapting legal search terms for use in these databases often involves translating legal concepts into discipline-specific terminology. For instance, searching for research on eyewitness testimony in a psychology database might use terms like memory recall or cognitive bias alongside legal terms. Subject-specific thesauri or controlled vocabularies in non-legal databases can help bridge terminology gaps and ensure comprehensive coverage. Citation indexes like Web of Science or Scopus can reveal interdisciplinary connections by identifying non-legal works that cite legal sources or vice versa. Constructing effective interdisciplinary search queries often involves combining legal and non-legal concepts, as in intellectual property or patent, and innovation and economic growth, for a law and economic study. Managing and organizing search results. Effective management and organization of search results are critical skills in the digital age of legal research, where a single query can yield hundreds or thousands of potentially relevant documents. Techniques for efficiently reviewing and categorizing large sets of search results often involve a combination of database features and external tools. Many legal databases offer features for saving and organizing relevant results into folders or collections, allowing researchers to categorize documents by topic, relevance, or research stage. Exporting search results to reference management software like Zotero or EndNote enables more sophisticated organization and citation management outside the database environment. Annotation and prioritization of search results, whether through database-specific tools or external note-taking systems, help researchers track key points and relevance assessments. Creating and maintaining a search log for complex research projects ensures reproducibility and allows for refinement of search strategies over time. Effective tagging or labeling systems for search results might include categories such as core cases, background information, or contrary authority. Techniques for identifying key sources from large result sets often involve scanning abstracts, headnotes, or relevance rankings provided by the database. Refining search strategies. The iterative process of evaluating and refining search strategies is fundamental to ensuring comprehensive and effective legal research. Methods for assessing the effectiveness of search strategies often involve analyzing the relevance and coverage of results in relation to the research questions. Techniques for identifying potential gaps in search results include cross-referencing bibliographies of key sources, consulting with subject experts, and comparing results across different databases or search approaches. Many legal databases offer analytics features that provide insights into the distribution of results across jurisdictions, time periods, or subject areas, helping researchers identify potential blind spots in their searches. Refining searches based on initial results might involve adjusting Boolean operators, adding or removing search terms, or modifying filters to better target relevant documents. Understanding and effectively using relevance rankings and algorithms provided by databases can help in quickly identifying the most pertinent sources, though researchers should be aware of the potential biases inherent in these automated systems. Adapting search strategies for different research stages from initial broad exploration to focused analysis ensures that the approach remains aligned with evolving research needs. Balancing precision and recall in legal searches often requires experimentation and adjustment. Overly precise searches may miss relevant materials, while broad searches can overwhelm with irrelevant results. Managing and organizing research notes. The importance of effective note-taking in legal research. Effective note-taking serves as the bedrock of rigorous legal research, playing a multifaceted role in the scholarly process. At its core, note-taking facilitates deeper understanding and retention of complex legal concepts, allowing researchers to engage actively with source material rather than passively consuming information. Well-crafted notes act as a bridge between reading and writing, streamlining the transition from research to manuscript development. For instance, detailed notes on landmark cases can expedite the process of constructing legal arguments by providing readily accessible summaries of key principles and reasoning. Moreover, comprehensive notes serve as a crucial tool for tracking the evolution of ideas and arguments throughout the research journey, enabling scholars to trace the development of their thinking and identify shifts in their analytical approach. This historical record of the research process is invaluable not only for the current project but also for future endeavors, allowing researchers to revisit and build upon previous work efficiently. In collaborative research projects, well-organized notes facilitate effective communication among team members, ensuring that insights and findings are accurately shared and collectively developed. Methods for legal research note-taking. Legal research demands a nuanced approach to note-taking, with various methods offering distinct advantages for different research tasks and personal preferences. The Cornell method, with its structured format of questions, notes, and summary sections, is particularly well-suited for case briefing and statutory analysis, allowing researchers to clearly separate facts, issues, and reasoning. Mind mapping, on the other hand, excels in visualizing complex legal relationships and hierarchies, making it invaluable for understanding intricate statutory schemes or the interplay between different areas of law. Traditional outlining remains a staple in legal research, providing a clear hierarchical structure that mirrors the organization of many legal documents and arguments. In the digital age, these methods have been adapted and enhanced through various software tools. For instance, annotation tools and PDF readers enable researchers to take notes directly on digital documents, maintaining a close connection between the source material and the researcher's thoughts. When dealing with case law, a modified version of the IRAC issue, rule, application, conclusion method can be effective for structuring notes, ensuring that key elements of legal analysis are consistently captured. For academic articles, a combination of margin notes and summary paragraphs often proves effective, allowing researchers to engage with the author's arguments while synthesizing key points. Digital tools for research note management. Ladies and gentlemen, the advent of digital technology has revolutionized research note management, offering a plethora of tools designed to enhance organization, accessibility, and collaboration. Popular note-taking software such as Evernote, OneNote, and Notion provide versatile platforms for capturing and organizing research notes across devices, with features like tagging, search functionality, and multimedia integration. These tools allow researchers to create hierarchical notebook structures that can mirror the organization of their research projects. Reference management software like Zotero and Mendeley offer specialized features for academic research, combining bibliographic management with note-taking capabilities. These tools enable researchers to attach notes directly to source entries, facilitating the organization of ideas in relation to specific references. Cloud storage services such as Dropbox or Google Drive provide seamless syncing of notes across devices, ensuring that researchers have access to their materials regardless of location. Legal research platforms like Westlaw and LexisNexis often include note-taking features tailored to legal materials, allowing for direct annotation of cases and statutes within the research environment. The choice of digital tools should be guided by individual research needs, workflow preferences, and the specific requirements of legal scholarship. Organizing and categorizing research notes. The organization and categorization of research notes is a critical task that underpins the efficiency and effectiveness of legal scholarship. A well-structured system enables researchers to quickly locate relevant information, identify patterns and connections across sources, and maintain a clear overview of their research progress. Hierarchical structures, mirroring the organization of legal systems or research projects, can be particularly effective. For instance, notes might be primarily organized by broad legal domains, e.g., constitutional law, tort law, then subdivided by specific issues or cases within each domain. Alternatively, a flat organizational system using robust tagging or labeling can offer greater flexibility, allowing notes to be categorized along multiple dimensions simultaneously. The use of metadata, such as date created, source type, or relevance rating, can enhance the searchability and sortability of notes. Organizing notes by research questions or themes can be particularly useful in the later stages of research, facilitating the synthesis of information across multiple sources. The development of a consistent and intuitive naming convention for files and folders is crucial for efficient navigation of large note collections. Color coding or visual cues can provide quick visual references, especially useful for distinguishing between different types of sources or stages of analysis. Techniques for summarizing and distilling information. The ability to distill complex legal concepts and extensive source materials into concise, meaningful summaries is a crucial skill in legal research. Effective summarization not only aids in the retention and understanding of information but also facilitates the synthesis of ideas across multiple sources. When summarizing case law, focusing on the key elements of the court's reasoning, the specific facts that influence the decision, and the implications for broader legal principles can provide a comprehensive yet concise overview. For statutory materials, summarizing the main provisions, the legislative intent, and any significant amendments or judicial interpretations can capture the essence of the law. In summarizing academic articles, identifying the author's main thesis, key supporting arguments, and any novel contributions to the field is crucial. The use of bullet points or numbered lists can help structure summaries in a clear, easily digestible format. Visual aids such as diagrams or flowcharts can be particularly effective for summarizing complex legal processes or the interrelationships between different legal concepts. When dealing with large volumes of case law, creating a table summarizing key facts, holdings, and principles across cases can facilitate comparative analysis. Integrating citations and bibliographic information. Dear listeners, the seamless integration of citations and bibliographic information into research notes is fundamental to maintaining the scholarly rigor and traceability of legal research. Accurate and consistent citation practices not only support academic integrity but also facilitate the efficient retrieval and verification of sources. Developing a system for shorthand citation keys that can be quickly inserted into notes and later expanded into full citations can significantly streamline the note-taking process. Reference management software can be leveraged to automatically generate citations and bibliographies, with notes linked directly to source entries. This integration ensures that researchers can easily access full bibliographic details and original sources from within their notes. When dealing with unpublished or informal sources, such as interviews or archival materials, it is crucial to develop a consistent system for noting provenance and access information. Creating annotated bibliographies as part of the note-taking process can provide a valuable overview of the literature landscape, combining source information with brief summaries and evaluations of relevance. Adapting note-taking approaches for different research stages. The approach to note-taking should evolve to meet the changing demands of different stages in the legal research process. During the initial exploratory phase, broad and flexible note-taking techniques are often most appropriate. Mind maps or concept notes can be particularly useful for capturing the overall landscape of a legal issue and identifying potential research directions. As the research progresses into more focused analysis, detailed and structured note-taking becomes crucial. For in-depth analysis of key sources, techniques like the Cornell method or detailed outlining can help capture nuanced legal arguments and their supporting evidence. During the synthesis and argument development phase, notes should focus on drawing connections between different sources, identifying gaps in the literature, and formulating original insights. When transitioning to the writing phase, notes often need to be restructured to align with the intended outline of the paper or article. Creating summary documents that consolidate key points from across various notes can be invaluable at this stage. For empirical legal research, maintaining a detailed research log alongside analytical notes is crucial for documenting methodological decisions and ensuring reproducibility. Ethical considerations in research note management. Ethical considerations play a crucial role in the management of research notes, underpinning the integrity and credibility of legal scholarship. Maintaining clear distinctions between direct quotations, paraphrases, and original ideas within notes is fundamental to avoiding unintentional plagiarism and ensuring proper attribution in subsequent writing. When dealing with confidential or sensitive information, such as in empirical legal research involving human subjects, notes must be managed with strict adherence to ethical guidelines and data protection regulations. This may involve anonymizing data, using secure storage solutions, or implementing access controls for shared notes. In collaborative research projects, establishing clear protocols for note sharing and authorship attribution is essential to prevent ethical conflicts and ensure fair recognition of contributions. The use of notes to maintain a clear audit trail of the research process, including decision-making rationales and methodological choices, supports transparency and reproducibility in legal scholarship. When notes include unpublished or personal communications, researchers must be mindful of privacy considerations and obtain necessary permissions before incorporating such information into published work. Maintaining objectivity in note-taking, particularly when dealing with controversial legal issues, is crucial for producing balanced and credible research. Collaborative note-taking strategies. Slide shows that the collaborative note-taking has become increasingly important in legal research, reflecting the growing trend towards interdisciplinary and team-based scholarly projects. Digital platforms such as Google Docs, Microsoft OneNote, or specialized academic collaboration tools offer robust environments for shared note-taking, enabling real-time collaboration and version control. Establishing clear protocols for collaborative note-taking is crucial, including guidelines on note structure, tagging conventions, and the division of note-taking responsibilities among team members. These protocols should also address how to handle disagreements or conflicting interpretations within shared notes. Effective collaborative note-taking often involves balancing shared spaces for collective insights with individual sections where researchers can maintain their personal perspectives and preliminary thoughts. Version control features in collaborative platforms are essential for tracking the evolution of ideas and attributing contributions accurately. Regular team meetings or virtual discussions centered around shared notes can foster deeper engagement with the material and generate new insights through the cross-pollination of ideas. In interdisciplinary legal research, collaborative notes can serve as a valuable tool for bridging terminology and conceptual differences between different fields of expertise. Reviewing, revising, and synthesizing research notes. The process of reviewing, revising, and synthesizing research notes is a critical phase in legal scholarship, transforming raw data and initial observations into coherent arguments and novel insights. Regular review of notes allows researchers to identify emerging patterns, recurring themes, and potential gaps in their research. This iterative process often leads to the refinement of research questions or the identification of new avenues for inquiry. Synthesizing information across multiple sets of notes is particularly crucial in interdisciplinary legal research, where insights from diverse fields must be integrated into a cohesive legal framework. Techniques such as creating thematic summaries, developing conceptual maps, or constructing analytical matrices can facilitate this synthesis process. As the research progresses, notes should be critically evaluated for their continued relevance and quality, with outdated or less pertinent information being archived or discarded to maintain focus. The synthesis of notes often forms the foundation for literature reviews or theoretical frameworks, providing a comprehensive overview of the current state of knowledge in a given legal area. Developing a systematic approach to note synthesis, perhaps involving regular scheduled reviews or specific synthesis sessions following major research milestones, can ensure that this crucial process is not overlooked in the rush of data collection and analysis. Creating an annotated bibliography. Purpose and types of annotated bibliographies in legal research. Dear listeners, annotated bibliographies in legal research serve multifaceted functions, acting as both a comprehensive catalog of sources and a critical analysis of the literature landscape. These bibliographies can be categorized into three primary types: descriptive, evaluative, and combinative. Descriptive annotations provide a summary of the source's content without significant critical assessment. Evaluative annotations, on the other hand, offer a critique of the source's strengths, weaknesses, and relevance to the research topic. Combinative annotations, the most comprehensive type, blend description with evaluation, providing a holistic view of the source. In legal contexts, annotated bibliographies find application in various scholarly endeavors, from preliminary research for academic papers to comprehensive literature reviews for grant proposals. Unlike standard bibliographies or literature reviews, annotated bibliographies offer concise yet detailed insights into individual sources, facilitating a quick assessment of their relevance and value. This format is particularly useful in identifying gaps in existing research, as it allows for a systematic overview of the current state of knowledge in a given legal area. Selecting sources for a legal annotated bibliography. The selection of sources for a legal annotated bibliography is a critical process that shapes the quality and utility of the final product. Researchers must employ rigorous criteria to ensure a comprehensive yet focused collection of materials. A balanced representation of primary sources, e.g., statutes, case law, and secondary sources, e.g., journal articles, treatises, is essential for providing a holistic view of the legal landscape. The relevance and authority of potential sources should be carefully evaluated, considering factors such as the author's credentials, the publication's reputation, and the source's impact on legal thought. In interdisciplinary legal research, the challenge lies in integrating sources from diverse fields while maintaining a clear legal focus. For instance, a bibliography on law and artificial intelligence might include technical papers on machine learning alongside legal analyses of algorithmic decision-making. Ensuring diverse viewpoints is crucial, particularly in controversial areas of law, to present a balanced perspective on the issues at hand. Researchers should strive to include seminal works that have shaped the field, as well as current research that reflects the latest developments. The scope of the bibliography, whether narrow and deep or broad and surveying, will influence the number and types of sources included. Structure and components of annotations. The structure of annotations in legal research typically encompasses 4 key components: citation, summary, evaluation, and relevance. The citation, formatted according to the appropriate legal citation style, e.g. Blue Book, Oscula, provides the bibliographic information necessary for locating the source. The summary offers a concise overview of the source's main arguments, methodologies, and conclusions. The evaluation component critically assesses the source's strengths, weaknesses, and contributions to the field. Finally, the relevance section explicates the source's significance to the specific research topic or question at hand. The length of annotations can vary depending on the purpose and audience of the bibliography, typically ranging from 150 to 300 words. Balancing descriptive and analytical elements within this concise format requires skill and practice. Effective annotations often employ topic sentences or subheadings to enhance clarity and facilitate quick reference. For instance, an annotation for a landmark Supreme Court case might begin with a brief statement of the case's significance, followed by a summary of the facts, the court's reasoning, and the decision's impact on subsequent jurisprudence. Techniques for crafting effective summaries. Ladies and gentlemen, crafting clear and concise summaries is a fundamental skill in creating effective annotations. The challenge lies in distilling the essence of often complex legal texts into brief, accessible synopses. For scholarly articles or books, this involves identifying and articulating the central thesis or argument, key supporting points, and significant conclusions. When summarizing case law, focus should be placed on the core legal issues, the court's reasoning, and the principle established or modified by the decision. For statutory sources, summaries should capture the primary objectives of the legislation, key provisions, and any notable interpretive guidance provided. In summarizing empirical legal studies, it is crucial to concisely present the research question, methodology, key findings, and implications for legal theory or practice. The use of legal terminology should be judicious, providing enough specificity for accuracy while remaining accessible to readers who may not be experts in the particular area of law. Avoiding excessive detail is critical. The summary should provide a clear overview without attempting to replicate the full complexity of the original source. For sources with multiple or complex arguments, prioritizing the most relevant or impactful points is essential. Critical evaluation in annotations. Critical evaluation is a cornerstone of effective annotations, transforming the bibliography from a mere list of sources into a valuable analytical tool. This component requires researchers to assess the strengths and weaknesses of each source, considering factors such as the soundness of methodology, the persuasiveness of arguments, and the reliability of evidence presented. For empirical studies, this might involve scrutinizing the research design, sample size, and statistical analyses. In theoretical works, the focus may be on the logical consistency of arguments and the originality of insights. Evaluating the author's credentials and potential biases is crucial, particularly in areas of law where perspectives can be heavily influenced by ideological or professional affiliations. The currency and relevance of sources to the specific research topic should be explicitly addressed, considering how recent developments in law or society might affect the applicability of older sources. In critically evaluating landmark cases or influential texts, it is important to consider their historical significance alongside their current relevance. Comparative evaluation, highlighting how sources relate to or contradict each other, can provide valuable insights into debates within the field. While maintaining a scholarly and objective tone, researchers should not shy away from identifying limitations or questionable assumptions in even highly regarded sources. Articulating source relevance. Dear listeners, articulating the relevance of each source to the specific research topic is a crucial aspect of annotations, bridging the gap between the broader field of study and the particular focus of the researcher's work. This component should clearly explain how the source contributes to understanding or addressing the research problem at hand. For instance, in a bibliography on digital privacy law, an annotation might explain how a particular article's analysis of data protection regulations informs the researcher's investigation of cross-border data transfers. Identifying and describing gaps that sources address or leave open is particularly valuable, as it can highlight areas for further research or novel contributions. Researchers should strive to draw connections between sources, noting how they complement, contradict, or build upon each other. For historical or foundational texts, the relevance discussion might focus on how the source has shaped current understanding of legal concepts or doctrines. When incorporating interdisciplinary sources, it is crucial to explicitly articulate their relevance to legal analysis or practice. In comparative or international legal research, explaining the relevance of foreign sources to domestic legal issues can provide valuable insights. Citation practices in annotated bibliographies. It's neat to note that the accurate and consistent citation is paramount in annotated bibliographies, not only for academic integrity but also for facilitating further research and verification of sources. The choice of citation style should adhere to the conventions of legal scholarship, with the Blue Book being the predominant style in many jurisdictions. However, researchers should be aware of variations in citation requirements across different legal systems and publications. Formatting citations for diverse legal sources presents unique challenges. For instance, citing cases may require inclusion of party names, court, year, and reporter information, while statutory citations often necessitate specific section or paragraph references. International or comparative legal research may involve citing sources from multiple jurisdictions, requiring careful attention to respective citation norms. Thank you for the attention.